I need you to sit back and enjoy this video, particularly if you're law students, a barrister in equity, or a new week. This video is a must watch for you because you need to prepare yourself. If they can just come and your principal will tell you, you know what, Mary, just go with this case file to court tomorrow. I will meet you in court, and you will not, your principal will be nowhere to be found. Okay, so you just need to actually prepare yourself. How to prepare your witness for examination in chief, or let me say for trial, how to prepare your witness to give evidence in court. Why this is important to prepare your witness is because many of the people that come to court as a witness, they don't know what is obtainable in the court. That will be their first time in the courtroom. So it is important for you to coach them, for you to prepare them, give them tips on what they should expect in the court and how they should answer questions. Okay, you cannot teach them, you cannot preempt the opposing counsel to say, okay, he will ask you this question, he will ask you that question, and give this answer. You can always preempt, it is possible, but my point is you cannot preempt to say this is all the questions the opposing counsel will ask and give your witness the possible answers. You can only preempt him in a little way, but you cannot, I'm sure you can't preempt everything the opposing counsel will be asking. So you just need to prepare your client on, okay, this is a smart way, this will be the smart way for him to answer questions. Okay, so number one thing I would say that it's important for you as a lawyer, or when you want to guide your witness, is to tell your witness, or when you are preparing your witness, is to tell your witness to come to court early. That is one. And another thing is for a witness to come to put on an attire that will make them comfortable. To make them comfortable doesn't mean they have to wear something that will be I don't know how to put it, something that they just need to appear formal. They need to appear neat. Okay, courts also take notice of things like that, though I am not saying things like that will actually amount to evidence, but to make them comfortable, it will make them to be respected and all of that. So coach your witness that the witness should appear in court in their best, in an outfit that they will be in, an outfit that will make them comfortable, and tell the witness to come to your office in order for you to coach the witness. If your witness can come a day before the hearing date, if for example tomorrow I'm going to court to actually with the witness to give evidence, today I will tell the client, the witness, to come to the office probably anytime I'll be free, or anytime the witness will be free, in order for me to guide, coach the witness, prepare the witness. Okay, and also you tell the witness to come to the court early. In order for you to ask those things, those questions, you must have coached the witness on and see if truly the witness actually catch everything. Like the day of the hearing, the first thing you need to do, if your witness is an elderly person, you may apply to the court for the person to sit. You know, someone who is just coming to the court for the first time, anxiety can actually take over the person. So if the person is an elderly person, or the person is sick, having health issues, you can always apply to the court that, my lord, I humbly apply that my witness should be allowed to sit, is an elderly person or is having some health challenges, and the court will definitely oblige the person. Okay, the court will definitely oblige the person. So that is number one thing, like a tip that I'm giving to the counsel before you start the trial proper. Okay, so you definitely will lead your witness examination in chief. I made a video on that, and also if there are documents to be tendered, you also do that as well. I also made a video on that. So then the opposing counsel will ask questions. You coaching your witness is basically to know, importantly, apart from when you must have coached the witness on what the responses you expect from the witness during examination in chief, or while tendering of documents. The major importance for me, the major importance is on how to answer the questions of the opposing counsel. Do not get me wrong. It is important for you to coach your witness for examination in chief as well. Okay, it is important, particularly when you're asked, okay, what do you want the court to do with this document, or what do you want the court to do for you, and all of that. You can always coach your witness on that as well. But it is more important for you to coach your witness when it comes to how to answer the questions of the opposing counsel, because lawyers, we are very smart. You can always find, we can find the way to just twist a question that can be asked literally, and the person will get, look, this question should be a no. But there'll be a way a lawyer will actually lay some foundation, and the witness will have no other choice than to just answer that question wrongly in the sense that will now be detrimental to your own case. So it is important for you to coach your witness, for you to guide your witness. So another thing is, try and preempt the questions you think the opposing counsel can ask. You cannot preempt him in all aspects, like all the questions he's going to ask, but can you preempt, okay, if this is a tenancy matter, you may be asking questions of, okay, when did you pay your last rent, and all of that and all of that. So you can always preempt those questions and also stand, coach your witness as if you are the opposing counsel. Try and ask questions that will make the witness be, that will make the witness dumbfounded. That way you can even check if the witness, if that person that will actually be a good witness for you. So you can always present and also stand as if you're the opposing counsel and ask those questions. So let me just talk about the tips that you need to tell your witness. Okay, number one is, tell the witness never to shout at the opposing counsel or at the judge. Never to do that. The opposing counsel may ask questions that may want to provoke the witness, and that will be your case as a lawyer to rise up and object the line of the question that probably it is provocative and all of that and all of that. But even if probably you are so busy writing something and you did not take notice of the tone of the question, just make sure you quote the witness never and never to shout at the lawyer or at the judge. That is one. Number two, I jotted them down. Number two is to always ask for clarifications or to tell the lawyer to rephrase the question. If a question is being asked and the witness do not really comprehend, it is important for the witness to say, can you rephrase the question, or can you make the question more, can you clarify, I don't really understand the question. Definitely just put some confidence in the witness that the witness, the judge will definitely ask the witness to rephrase or to yeah, put the questions in words that will be better for the witness to answer, because it is important for a witness to understand a question before providing answers. So that is another point. And also make your witness understand that he or she needs to be consistent with the earlier statements. If the opposing counsel is asking the witness a question that probably the witness has given evidence on doing examination in chief, the answer has to be inconsistent with that, because the essence of cross-examination is actually to discredit a witness. So if you have said A during examination in chief and now you are saying A raised to power 2 in cross-examination, the witness is already saying things that are inconsistent with the earlier statement, and that way it will make your own case, it will make your own case, it will be detrimental to your own case. So another thing is, the witness should never guess answer. You should never provide an answer based on, okay, I think it should be this. It would be best for a witness to say, I don't know, or I can't really say, I can't remember. It all depends on what the judge can infer from it, but I can't say I can't remember would definitely to me not mean a yes or a no. Okay, so if a witness is like, I'm dumbfounded, what does it mean? What does this thing really mean? Probably after the witness informed the judge, the opposing counsel like, oh, can you please rephrase the question? I don't really understand what you actually mean by this and all of that. And even at that, the witness still can't understand the question. It would be best to say, I can't really say, or I don't really know. But if it's something that you understand and probably you have given an evidence in that regarding your examination in chief, you just need to give that same answer. I'm saying all of this like if I'm directing it to a witness. Just make sure you pick the information in this video and just direct it to your witness, okay? So that is another thing. And if you can't remember something, just say I can't remember or I don't understand. Another thing is, you should listen carefully. Inform your witness to listen carefully before providing an answer. What is the point of you not understanding an answer and your a question and you're providing an answer? So you need to listen carefully. And if you did not catch anything, you can always say, sorry, I did not catch what you said, Ella, like I didn't hear or you weren't audible enough. You can always refer the you can always tell the opposing counsel that, or just face the judge and tell the opposing counsel that. Another thing is, inform your witness to only provide answer to the question that will be asked. Okay, if the lawyer is asking what is your name, you should just say my name is XYZ, not my name is XYZ. I originated from so and so, I attended so and so. You have answered the question, but you're giving more details. Okay, just tell the witness always answer the question that will be asked. Okay, and also to guard his or her emotion, because I know particularly in lower courts, you see a lot of opposing counsel trying to actually ask provocative questions in order to just annoy the witness and for the witness to just misbehave in the courtroom. And when someone's emotion is high, person may battle with on how to control his train of thought. So it is important for you to just guard the witness, like, you know what, it is possible for the lawyer to ask some questions that may be provocative. Even before I raise an objection, you must probably you have already listened, you already the lawyer already asked the question and it's quite provocative. I will be there to put your best interest to actually raise objection. But even when such question is being asked, please, I don't need you to overreact. I don't need you to say things to actually get the lawyer annoyed too, or to just utter some words that you shouldn't have say. So just try and guide the witness on how to actually go about things like that. I hope I've been able to actually share some educative information to you as a new week or as a law student. Okay, thank you so much for watching, and I will see you in another video.